So we've got our next session now, which is on first languages and intellectual property. And I've got three guests who are joining me here. And we're going to try and make this a bit of a discussion. Down right at the far end, I've got Robin Ayres, who has been a lawyer for over 20 years and is the CEO of the Arts Law. And in 2004, under the direction of Robin, Arts Law established the Artist in the Black Service, a legal advice service specifically for Indigenous artists. So welcome, Robin. Next up, we've got Tasha James, who's from the National Film and Sound Archive. She's a proud Wiradjuri woman and the Indigenous Connections Manager at the National Film and Sound Archive. Welcome. And right next to me, I've got Dr. Kathy Bowery, who's a professor in the Faculty of Law at UNSW, the University of New South Wales. I'm a student there. And her research explores laws and practices that inform knowledge creation and the production, distribution and reception of technology and culture. Great. So welcome to the panel. Have you all got your mics? Okay. So I thought we would have a bit of a yarn around intellectual property, conserving, disseminating language, any of the issues that arise, and I guess speaking from each of your different perspectives, what your role, what you see as your key role, and I guess how people that are within the room, whether they're within language centres or they're just community or stakeholders, may be able to, I guess, get support or advice. I might start with you, Robin, around what IP protection is there available under Australian law?
Before I start, I'd like to also acknowledge the traditional owners of the country where we're gathered here today and pay my respects to the elders. So I'm a bit of a fish out of water here, I have to admit, because I run the Arts Law Centre of Australia, and what our role is to give legal advice to artists and other creators and arts and creative organisations right around Australia. And as you mentioned, we do have a specialist Indigenous service at Arts Law, which was actually seed funded through the Australia Council back in 2004. So, and that's called Artist in the Black. And I imagine that's why I'm here today, because a lot of what we do at Arts Law is talk about helping creators with their intellectual property and looking at ways to protect it and also how to use contracts. So in terms of intellectual property, there is a slide, if we flick forward a few, which has an umbrella on it. So intellectual property is an umbrella term. And it is really an umbrella term describing the property of the mind. And in Australia, that's made up of pieces of legislation and as well as some judge-made law, some areas where it's decisions of the courts. So the first 5 acts, which I've got listed, are pieces of legislation that provide different sorts of intellectual property protection. So the primary one that we deal with at Arts Law is the Copyright Act. I'm going to tell you a little bit about what's in that Act. The other one that's really, or two I suppose, that could be really important to the topic that we're talking about today is around confidential information, protections, and also Indigenous cultural and intellectual property. Now, the problem with the Indigenous culture and intellectual property, it's not a problem, it's fantastic. If you look at the next slide, you'll see that Indigenous culture and intellectual property is an expression that fabulous lawyer Terry Janke, who's a Torres Strait Islander lawyer who works in intellectual property, termed when she did her report called Our Culture, Our Future. And this diagram really sets out what is covered, what Indigenous people in Australia saw as the need for protection in terms of their intellectual property. So right at the top of that slide, you've got the ones which are protected by copyright. So things like literary works, performances, film, artistic works. And then around the rest of the circle, there are all the other areas of intellectual property which there may be some forms of protection in terms of things like sacred sites. There might be heritage laws and native title, which provides protection. There are stories. Now, that's a problem if they're not written down, but if they're recorded in some way, they may be protected. But languages is an area where the language as a whole is not protected by intellectual property laws. So whether it be an Aboriginal language or the English language or French, the language is not protected. What is protected is the way that language is recorded in some form, in material form. So if we go to the next slide, just to kind of break it down a little bit more. So to get protection under the Copyright Act in Australia, you actually have to fit within one of the areas of subject matter that the law protects. It has to be recorded in material form, so that means it could be written down. If it's an artist, it's their painting or the etching, photographer takes the photograph, a filmmaker makes the film. So they're all recorded in material form, and then work has to be original to some extent, and basically means not copied, and also there has to be the requisite connection to Australia. That's not really a problem for anyone here. But what does this copyright protect? When I say the subject matter, it has to fall within the list. So I'm trying to give you a really quick, a very quick introduction to copyright law. So if we look at the next slide, it has what is actually protected under Australian copyright laws. We have literary works, so they're things like books, lyrics, computer programs. They're all literary works. We have artistic works, which includes things like photographs, musical works, dramatic works, and then we have films, sound recordings, broadcasts and published editions. Now, things like multimedia and websites and apps, they probably have component parts of all of these things. So there may be text, that's a literary work. There may be a song, that's a musical work, but it may have lyrics, so that's also a literary work. So you can see that there are all these different component parts, and then each of them might actually have different copyright owners. And so in order to be able to use copyright, the person who owns the copyright is the person who basically controls the right. They have the exclusive rights to decide how the subject matter is going to be used. So in terms of what those rights are, they get the right to copy it, they get the right to publish the work for the first time, to communicate the work, put it online, put it in an app. They get the right to perform the work, and they get the right to make adaptations of the work. So they're exclusive rights. So the thing is, in terms of who owns it, and this is where it gets tricky for things like languages and copyright, because the copyright law basically says that it's the creator or the author or with a film, the producer who actually creates the work. So it's the person who uses the intellectual effort to put it into that material form. So, and you can have joint copyright, but the issue here is with languages, and if you're developing language resources, then if it's the linguist, or if it's the person the consultant that you've brought in to develop the dictionary or the grammar or make the ebook or develop the app or the computer program, they're the person who, under just what the basic rules are in the Copyright Act, who would own the copyright in it. And so, you know, that's something that we've really had to grapple with. And so the way to change that, or to share it, or to change the ownership of the copyright, is to actually put contracts in place which can deal with that. And so that's the way that we have gone with working with, in all sorts of different areas, is using contracts to help both the creator and also communities control their intellectual property.
So that's really important because we've heard about people developing and creating resources and using different types of platforms. So I guess just the key things I've taken away there is, so language itself is not protected. It's the way that it's recorded and all of these things that you've got up there, such as record, film, computer, those sorts of things are the things that can be copyrighted. But I think the really most important point there is, whoever is the creator, the actual author, and if we're having people come into community that are helping to develop them, that ultimately, unless there's contracts in place, they will have that ownership. Yeah. So I just wanted to cross to Tasha now, because you would have experience with this in your space quite regularly through the National Film and Sound Archive. What's been your experience with this? And you've got some protocols and a framework. So could you talk us through that?
Yeah, so I work at the National Film and Sound Archive as the Manager of Indigenous Connections. I work in the capacity of advising our curatorial team and access areas in regards to Indigenous cultural and intellectual property. And just in regards, just adding to what you were saying about that copyright issues, we come across it a lot in regards to providing access to the materials that are in these collections. I also came across it a lot working for iAccess when I managed the access to the collection there. So how do we work through it? It's about engaging with you guys, the knowledge holders who know the collections. It's building relationships and including you all in the, management of these materials. We did a lot of work with Terry Jenke as well. She's actually our go-to expert in this space. So at the National Film and Sound Archive, we have an ISIP protocol document that sits across everything we do at the archive. Let's go through to our actual guiding principles. Yeah, that's the one. Okay, so the first one there, where we're talking about respect for Indigenous people, culture and heritage. This is about the organisation recognising and respecting and promoting your rights and to safeguard your intangible heritage contained within NFSA's recordings and appropriate copies of the holdings. And also looking at, repatriating these collections to the communities for cultural maintenance. Also, I'll expand on self-determination. The National Film and Sound Archive encourages Indigenous people to use and access the National Film and Sound collection and to provide guidance to the NFSA on cultural matters. So in regards to that, that's about us working with communities, going out in community consultation when people like filmmakers, publishers want to use the material for, making a film or a doco or something like that, then we refer them to the community to get that clearance. And also we provide them with our ISIP guidelines to make sure that, the right thing's being done. Interpretation, so this refers to Indigenous people have the right to be recognised as the primary guardians and interpreters of their own culture. So that's a really, really good, important, I think, message there, protocol there. Just about, it's not about misrepresentation, it's about Aboriginal and Torres Strait Islander people telling their own story. It's not being told for them.
I was going to, because I think these are really valuable, and I like that you said that you provide these materials out, and obviously language centres would have the opportunity to pick those up. But who monitors these to ensure that they are adhered to, or do you think that Australia actually needs to do more in this space around ensuring that Indigenous people and communities are protected under ICIP and these particular principles?
Oh, absolutely. I think that this needs to be sort of at that, high level, that there needs to be a legislation regarding the ISIP and that, this is to be recognised. People don't understand that For example, when we're providing access to language material and we have to turn around and tell the language centre, sorry, no, we can't provide that because the copyright is with, a linguist that, did their research back in the 1970s and now are based overseas because they hold the copyright. So it's about working with the communities and getting these cultural agreements in place.
So most of the people who are going into communities and doing language works are funded by some kind of public money, and to the extent that they're involved with a public institution, there is probably a requirement in place that they apply for ethics agreements before they actually go in. So even without needing legislation, that researcher has had to say to their university that they are abiding by cultural protocols. There is usually an Indigenous member of that. And so if you are unhappy with how your material's been used or with those cultural agreements, there is an institutional spot coming from the funding body. And whilst on one level people might think, oh, these are just ethics and they'll just brush it off, it actually affects the right of that person to get money again. So even if in some cases it's very difficult to redress the harm done, you can do a lot of damage to bad people's reputations that way if you want to. And so I do think people have to think more creatively about ways of actually dealing with law and law-like processes than just looking for things like legislation, because we know that's very difficult, and when you get it, it may not be what you thought it was going to be anyway.
So basically what Kathy's telling us is that, if the ownership or rights belong to somebody else, that you do have, if they're working for an institution such as a university, you can challenge whatever their funding body or that institution based on ethics, because they would have had to put an ethics proposal or agreement forward to have that approved. Is that right?
Yeah, that's right.
Yeah, great. So do trademarks protect Indigenous people?
So trademarks protect the person who have registered the trademark, okay? But a trademark is often thought about in the communities as a much stronger form of protection than it really is. Trademark is just a brand that protects that person's brand against other brands in the marketplace. And when the government body, IP Australia, decides that you're allowed to have that trademark, they don't actually think about its effects on the wider community. They're just looking at whether or not that trademark affects other traders wanting to use those types of words and images. But one of the things that could be done if people wanted to with language resources is pushing with IP Australia about them considering Indigenous language resources when they decide to actually grant a trademark. Because if I apply for a trademark tomorrow, they actually do a search and they look up the Macquarie Dictionary, they look up the Oxford English Dictionary, they look up a whole range of other databases, they look up atlases to decide how that word is actually being used and who it actually affects in the community. Okay. At the moment, there's no interface between what you guys are doing with language and what that kind of body is actually doing. It doesn't necessarily mean they would not register Aboriginal words in ways that might upset people, but it starts a conversation and keeps the pressure on to actually make language more visible in a way that actually is appropriate to Aboriginal Australia.
So we've got a couple of questions that have popped up on the Slido. And if you've got any questions in the audience as well. So I've got here, I understand that native title legislation also has intellectual property rights matters that could impact on our work, and we should be aware of that. Is that correct?
My understanding is with native title that native title doesn't extend to basically intellectual property rights. There was a case in Western Australia a decade or so ago, and they looked at whether the intellectual property rights was a component of native title. I don't think that's changed, but it hasn't. It's not something. I think that's what the law is at the moment.
Can copyright law provide protection for integrity of the language if the language is corrupted, misspelling, ungrammatical sentences?
Not really. No, what copyright protects is how the language is actually, that resource that's being created. So if someone creates a resource and there are those sorts of errors in it, copyright protects the resource as it is. So that's what the protection that copyright provides. I just thought, I don't know if this is interesting, but we've done a lot of work with the Mowanjum Arts Centre in Western Australia, in the Kimberley in Western Australia, and they are 3 tribal groups that have the rights to depict the Wandjina, that creation hero that you probably, a lot of you would be familiar with. It looks a little bit like a spaceman with the lightning and the clouds, 2 big eyes, no mouth. And they really been very distressed by some of the uses of the Wandjina. And so they asked Arts Law, what could we do to protect it? We ended up working with Allen's, a law firm, to actually get a trademark, and the CALIC, the Cultural Centre of the Kimberley, they own the trademark on behalf of the 3 groups. And the thing is, that trademark, so they have the name and then they have a depiction of the Wandjina that they have the trademark over. But the thing about trademarks, you only get it in classes of goods and services. So they have it over a number of classes and goods and services, but it still doesn't stop people misusing the Wandjina. It's only if they're using it in the context of one of those goods and services that it actually provides any protection. So it is very limited.
Okay, any questions from the audience? Oh, yeah. Can I get a mic over the back there?
I've got a question about where copyright and intellectual property might be crossing over. So, to do with basically grammars and dictionaries where grammatical information is included. So, as time has gone on, language centres, for example, have started copyrighting these publications under the language centres on behalf of the people. In the past, sometimes the linguists had some kind of copyright in there that might have gone away. But there's an intellectual property issue, which is that the analysis of the grammar, which is obviously appears in English, in these in the grammars and dictionaries, is actually really the intellectual property of the linguists. But it's based on the language that they've been given by the speakers that they've been working with, and. Obviously linguists, in the academic community in particular, will continue to work on languages and will continue to work in the sort of academic space of analysis and all of that other stuff. But sitting behind it still is that original language that was given. I'm not saying this is always a problem. Sometimes it can be a problem, but in general it's not a problem. But I'm just interested in where the copyright and intellectual property thing actually, blends there, if there is an answer to that.
Well, I guess it's just going back to what Robin first said about copyright and language. By law, nobody has copyright over language. We don't have an inherent, copyright of language. So I guess, that's what sits above it.
And I think that you're talking about the knowledge that the linguist might have.
Yeah, the intellectual property of the linguist is because the analysis is within all of that westernised linguistic framework.
It's the whole thing about knowledge itself isn't protected by our intellectual property laws. So that's the knowledge system, whether it be the linguist or whether it be your knowledge systems that you have, that's not protected under copyright or any of our intellectual property laws. What is protected is the way that the knowledge or the intellectual property is actually recorded, how it's put down, captured in material form. So yes, behind everything there's some sort of intellectual knowledge, expertise or creativity, and it's the way it's depicted that gets the protection. So there's nothing to stop someone who has that knowledge base then continuing to use their knowledge in other ways. It's like there's a story, and then there may be so many different ways of telling that story, and each time the story can be told in a different way, using different words to tell the story. Each one might get copyright protection, but you just can't take one story and use it and basically write the same story or a similar story.
But can you see what I'm saying? Where it's just the questions that people have, because obviously in the past it's not happening anymore. But the idea that linguists and anthropologists came and took stuff away. And that, you know, so it's just that question that people have. But the linguistics is always based on the actual. I know you say can't have copyright over knowledge or whatever it is, but the expression of the language that Aboriginal people, you know, the way that they express their language, the way it's then interpreted in the grammatical, but that comes out in English. It's I mean, maybe I'm just not expressing myself,
I've got,
but
I guess, two ways of approaching what you're asking about. One is that I think often people are looking for laws and rights for answers when really what they're talking about is trust. And one of the issues there is that law is always something that operates against a background of existing relationships and trusts and other things. I mean, no, law doesn't exist on people running to rights to enforce them in the courts. You know, that's the last resort. It operates on other things. So I think that's one thing to keep in mind. The other thing is that in relation to how law is used, I think that one thing that needs to be looked at more is how powerful people use the law. Because I think when people do legal education with Indigenous people, a lot of the story is one about how you can't do this, you won't be able to do that, the law doesn't. And I'm not saying that anything that anybody said here is wrong. There are a lot of limitations, but there is also an awful lot that is up for negotiation. So in terms of your question, even though we know that law is inadequate at dealing with what might be legitimate expectations around controlling the use of the linguist's work, you can still try to actually hold that into some kind of document what the agreement is around that and put those types of pressures in it. And I think that's to me that's how law actually contributes to trust. You use those types of forms, but you have to have the conversations before people get there about what you're comfortable about, and you have to revisit them as things develop and have a think about whether or not it's still working and what else you could change.
So can I just ask a quick question then, based on what you're saying? So this is for something that's happened in the past where maybe that hasn't happened. A linguist can't actually charge a community who wants their materials back.
It would depend on what you mean by their materials. I would have thought it would be very difficult for the community.
The language side of what's being collected, where the linguist is arguing that they did all the other stuff, but the actual language.
I would have thought that the same limitations on protecting language is going to bite the linguist in that sort of circumstance. It's if you've actually physically got access to the resources, I'm not entirely sure why you would need them.
I have a question about whether IP is dynamic. Shift happens, and it happens also legally. My question is whether you have a specific hypothesis about one aspect that currently is considered soft law, so it's not a matter of hard law, that you believe in 20, 30, 50 years might become hard law. So in other words, something that you said is currently just, if you're a kind person, you will follow the protocols, maybe it will become part of the hard law. Do you see something like that happening?
I have a trouble with the soft law, hard law distinction. I have no confidence in Australian legislative processes. Actually, I mean, what you're going to get is never Aboriginal law. You're going to get something else. It's like the difference between Aboriginal concepts of land and native title. They're not the same thing. One's, there's no actual comparison between one and the other. They're entirely different forms of expression. So I think that if you're talking about Indigenous protocols becoming Australian law in terms of Australian parliamentary law, I don't think that's something the Australian parliamentary system is able to deliver. I think that needs an international dialogue.
So language is, as I understand from you, is intangible, so you do not own it, and that's it. My question is whether or not in the future, it has to do with what you said, Indigenous and non-Indigenous, but whether there will be more awareness about intangible assets, which means that what currently is considered to be, for example, when I give a lecture, everybody can quote or whatever. I do not have any intellectual property over it. I mean, you can, but my question is whether in the future it will be more, it will be more regulated than today. So if we invite you in 50 years' time, you will tell us different description of the current law.
I'm sure I won't be here, but I suppose there's one thing is we've got the Declaration of the Rights of Indigenous People, and that does include in it a a provision which provides a greater level of protection for Indigenous culture and intellectual property. So I know there would be a lot of people, and I'm probably one of them, that would like to see stronger legislative protection in Australia. So I probably differ from Kathy, and I do agree, though you won't necessarily get what you are hoping you'll get, but you might be able to get something better than what you've got today. The other is really need for huge education of the whole Australian population and developing a much greater level of awareness and respect around the fantastic cultural resources and everything that we have in this country that people just have got no idea about. Then maybe we will start to see, you know, a much more respectful relationship with all things Aboriginal and Torres Strait Islander.
So can I just jump in and say one more thing? That I don't think people should come away with thinking that you have no protection at all. It is piecemeal and it's tricky, but it does actually exist, and there are ways in which these laws can be made to work for Indigenous people. So I don't think you should just assume that there's nothing.
And I'll just add just to that. And just coming from working within the cultural sector with the Indigenous collections, I would like to see that the ICIP protocols are adopted by all, collecting agencies that do have our materials in them. You know, they have to have these protocols. You know, it's important to have those protocols to protect the material.
And if there's one more thing I could say, I don't know if we're out of time, but back in 2004, Arts Law was approached actually by Faith Basden, who's sitting in the room here, to develop some agreements to use for language resource projects to help manage the intellectual property in those projects. So we worked with what was then FATSL on developing these 3 contracts. And also the other thing that we did at the same time, or basically Faith did it working with her team, is develop a language protocol that sat alongside the language contract, and the contract made the protocol binding. So people who were engaging in that project and signing up to work on the project agreed to the protocol, and that then became a binding obligation under the contract. So that's really sort of taking what Kathy has said about using the legal system to your advantage to make sure that it's working for you and the projects that you're working on.
Okay, we're going to have to pull it in there because we are fairly over time. There was just one question that just come up to me. If a linguist writes a dictionary, who owns the words? Is it the linguist? No?
Not the words.
So a dictionary is a compilation of words, and copyright doesn't attach to the individual words, it attaches to the compilation of it. So it's like the collection of it, which means that when you go into compile, or somebody's going to compile those, you have to actually think about that in advance, about if you're going to share it, an individual's going to own it. But it can be protected that way. So, as you know, J.K. Rowling is very, very good at protecting dictionaries and made-up words. And so I think that's something that Indigenous people need to look at, and look at the way that she's done that.
Okay, thank you so much. Well, I'm sure we had more time, we would have had a lot more questions. Don't try and bell me now. You always got to get that out. Just want to stir me up all the time. So look, just join me in thanking Robin, Tasha and Kathy.